Hidden risks in asset protection strategies. Properly structured and implemented asset protection strategies can provide significant benefits, yet even the most robust legal structures carry inherent, often invisible, risks. While the primary goal is to insulate wealth from creditors and litigation, the trade-offs, legal, financial, and personal, can be severe if not meticulously orchestrated and implemented. One of the most immediate hidden risks is the claim of fraudulent conveyance, which occurs when a court determines that an asset transfer was made with the specific intent to hinder, delay, or defraud a creditor. This often arises when individuals attempt to move assets after a legal threat has emerged, triggering badges of fraud that allow a judge to unwind the entire structure. Even if a plan is established early, the timing must be beyond reproach. If a transfer makes the debtor insolvent or occurs near a foreseeable liability, the legal protection can vanish. Consequently, a strategy meant to save assets can instead result in costly litigation, court-ordered reversals, and potential sanctions for all parties involved. Beyond legal challenges, the loss of direct control and ownership represents a significant psychological and operational risk for the grantor. Most effective asset protection tools, such as irrevocable trusts, require the individual to legally relinquish title to their property to an independent trustee. This means you can no longer unilaterally sell the asset, change beneficiaries, or use the funds as personal collateral without trustee approval. If the relationship with the trustee sours or if your personal financial needs change unexpectedly, you may find yourself legally impoverished while your wealth sits just out of reach in a structure you no longer govern. The tax and regulatory compliance burden of advanced protection strategies, particularly offshore structures, is frequently underestimated and can lead to aggressive government scrutiny. For instance, the IRS and other tax authorities maintain strict reporting requirements for foreign bank accounts and trusts, such as FBAR and Form 3520. Where minor errors can trigger draconian penalties. Furthermore, transferring assets into a trust can lead to the loss of certain tax benefits, such as the step-up in basis at death or primary residence capital gains exemptions. Without a specialized tax advisor, the protection gained could be wiped out by the very tax authorities you weren't even trying to avoid. Another subtle risk is trustee or management malpractice, where the security of the assets depends entirely on the integrity and competence of a third party. When assets are placed into a trust or a limited liability entity, the grantor is vulnerable to the trustee's investment decisions, administrative fees, or even outright embezzlement. In offshore jurisdictions, this risk is magnified by the difficulty of pursuing legal action in a foreign court against a non-resident trustee. If a trustee manages the assets poorly or charges excessive maintenance fees, the erosion of wealth can be more damaging than the original creditor threat you sought to escape. Institutional and jurisdictional instability poses a macro-level risk that is often overlooked during the setup phase of an offshore asset protection trust. While a specific country might currently offer favorable privacy laws and anti-duress clauses, international pressure or domestic political shifts can lead to sudden changes in legislation. Global transparency initiatives, such as the Common Reporting Standard, have already significantly diminished the anonymity once associated with these jurisdictions. If a jurisdiction loses its reputation or changes its laws to cooperate with foreign courts, the impenetrable shield you paid for can become a liability overnight. Finally, there is the risk of false security and piercing the veil, where minor operational mistakes completely invalidate the protection. For strategies like limited liability companies, LLCs, if the owner treats the business account as a personal piggy bank, known as commingling funds, a creditor can successfully argue that the entity is a mere alter ego. This allows the court to pierce the corporate veil and reach personal assets despite the formal legal structure. Therefore, the strategy is only as strong as the rigorous, ongoing administrative discipline of the person using it. A single personal charge on a business card can bring the entire fortress down. To learn more about our law firm's international corporate legal practice, we welcome you to visit our website or contact our law firm to schedule an initial consultation. Thank you.